No. Subcommittee will come to order. Without objection, the chair is authorized to declare a recess at any time. We welcome everyone to this hearing of the Subcommittee on Responsiveness and Accountability to Oversight. Begin by leading us in the pledge. Would everyone please rise? Flags in the back. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. All right, thank you. We'll begin with opening statements. Chair recognizes himself. Since the beginning of the Biden administration, committee Republicans have made at least 50 different requests for information and documents concerning the operations and actions of the FBI since the onset of this administration. Committee Republicans have sent numerous requests to the Biden FTC. These requests include the FTC's harassment of Elon Musk's Twitter, the abandonment of long-standing bipartisan antitrust standards, and the FTC's extraordinary decision to ban voluntary non-compete clauses in employment contracts, supplant state laws without legal authority. The absence of a sound and transparent administrative process results in failed and costly government policies. This is what we are seeing unfold at the FTC under Chair Lina Khan. It's incumbent on Congress to provide oversight for these matters, and such oversight will remain necessary while the FTC continues to take actions on matters its enabling statute does not authorize. Additionally, since the fall of 2021, the committee has requested information and documents concerning the operations and actions of the Department of Education. The committee has reiterated some of these requests multiple times. On February 3rd, 2023, in the face of continued obstruction, Chairman Jim Jordan issued subpoenas to FBI Director Wray and the Education Secretary Cardona for documents. And unfortunately, the committee continues to have concerns about the responsiveness, not only of the agencies, but of the very documents that they have provided. For example, on March 1st, 2023, the day the FBI was to comply in full with the subpoena, the Bureau produced just 4 pages of school board-related documents. While the FBI has since made additional documents available to the committee pursuant to the subpoena, questions remain, and the committee awaits the Bureau's next production. We invited the FBI to testify at the last hearing on March 9th, 2023, but the FBI refused. Although we were disappointed the agency was not there, the DOJ and the Education Department testified before the subcommittee regarding the agency's compliance with the committee's subpoenas and various requests. And while the witnesses made some commitments to the committee during their testimony to produce certain information, they otherwise provided underwhelming testimony and responses to members' questions. Actual evidence that was required, that was requested, and would have been of interest to the committee was in fact provided in a tranche of documents the day before, and despite every effort by the staff to go through all the documents, we didn't actually get through the documents before the hearing on the day after they were provided. We look forward to today to engaging with the witnesses that have appeared to discuss the productions that we have received to date and regarding the status of our other outstanding requests. These officials are charged with the responsibilities of working with Congress, coordinating policy, and they play a key role as a gatekeeper of witnesses and information. And these hearings play a critical role in assisting the committee in its oversight obligations, which in turn allows the committee to examine potential legislative changes within our jurisdiction. The courts have recognized that Congress's power to conduct oversight is an indispensable component of our authority to legislate. Without the information that the committee needs from the Biden administration, we cannot do our jobs. This committee, the Subcommittee on Commitment and Accountability to Oversight, which is not the actual weaponization committee, as much as the ranking member may claim that it seems to be, this committee will not allow delay and indifference to obstruct the legislative process. I look forward to hearing from our witnesses today how their respective agencies will comply with the requests made to them. And now I yield time to the ranking member, Mr. Swalwell, for 5 minutes.
Well, here we are, another partners meeting of Insurrection LLC. That's what this is. This is the newly formed largest law firm in Washington, D.C. Only has one client, maybe a second client that we're going to learn about today, but that client is former President Donald Trump. Their job is to litigate every one of his petty grievances. Perhaps the next client is Elon Musk, and that's why FTC has been called here today. But Jim Jordan's obstruction of justice committees that he's overseen have less credibility today than they did when we convened just 3 weeks ago. It's now 321 days since this subpoena was sent to Jim Jordan that he did not comply with. So it's comical that we are here today under Jim Jordan's leadership asking people why they don't want to comply with subpoenas. The guy won't comply with the one that was sent to him 321 days ago. Witness to a crime, the crime that has led to more arrests than any investigation in America. He's a witness being asked to do his patriotic duty and respond to a subpoena 321 days later, refuses. Also, since the last hearing of this committee to obstruct justice, Chairman Jordan is now interfering in an independent criminal prosecution. There's an investigation in Manhattan, also in Atlanta, also at the Department of Justice, into the former president. And Jim Jordan has sent a letter to the independently elected District Attorney Alvin Bragg of Manhattan. He is asking Alvin Bragg to commit a felony. Why is he asking Alvin Bragg to commit a felony? To help Donald Trump. Why is it a felony? Because if Alvin Bragg were to turn over what Jim Jordan is asking, Alvin Bragg would be violating New York law that says you cannot turn over grand jury proceedings. But that's what they're asking him to do. Again, the law doesn't matter if your client is Donald Trump. The other day, Jim Jordan was asked, well, what do you think of the former president who put out on Truth Social the other day essentially another call to action, a January 6th-like post, when the former president said this posting. Jim Jordan was presented with this post by the former president that calls for death and destruction. And Mr. Jordan said that he would need his glasses. He was looking the other way. Jim Jordan looking the other way. Well, we have blown up on the screen, and we've put it right here, and I'll leave it for Jim Jordan. This is what Donald Trump said, Mr. Jordan. What kind of person can charge another person, in this case a former president of the United States, who who got more votes than any sitting president in history and leading candidate by far for the Republican Party nomination with a crime, when it is known by all that no crime has been committed, and also known that potential death and destruction in such a false charge could be catastrophic for our country. Why and who would do such a thing? Only a degenerate psychopath that truly hates the USA. Again, I'm going to leave this up here in probably 200 font, so Mr. Jordan doesn't need his glasses to read it. The same individual who posted this also posted this photo. There you go, Donald Trump, real tough guy, holding a baseball bat next to a picture of that independent prosecutor that Jim Jordan wants to commit a felony, Alvin Bragg. But you won't hear from this committee to obstruct justice any condemnation of what Donald Trump posted. They can't condemn him. They can't. So, in their silence, they condone it. And in these posts from Donald Trump, he incites more and more Americans to commit violence, like a woman who was arrested yesterday near Times Square with a knife, seeking to carry out an act of violence in Donald Trump's name. So what has changed since the last hearing? Well, we have now learned that the FBI investigated tips that they were asked to investigate through a tip line. That's their job, to run down every single lead. Parents have every right to advocate on behalf of their kids. I have 3 little kids. When they get older and go to school, I will be a fierce advocate for their education. No parent has a right to threaten a school board volunteer. If a threat is brought to the FBI, it's their duty to investigate those threats. We have also learned from all the document production from DOJ and the FBI and the Department of Education that there is not one instance where the Department of Justice called any parent or a group of parents domestic terrorists, as has been claimed by Jim Jordan. We also learned at the last hearing that this isn't really about parents and kids at all. Mr. Van Drew spent almost all of his time wanting to go into the Mar-a-Lago search. Again, this is about one client and litigating his grievances. But it's also about a tweet that Jim Jordan posted back in the fall. Kanye, Elon, Trump. Now, after that tweet was posted, Kanye said he's going to declare DEFCON 3 on the Jews. The tweet stayed up for months. Everyone was like, hey guys, turns out your hero, Kanye West, hates the Jews. We all stand with Israel. Please take down the tweet. They didn't take down the tweet. They kept the tweet up. Day after day, Jewish community, they're hurting. They say, please don't put this tweet up. It stays up. So we can cross Kanye out, but it looks like we're here today for the other two, Elon and Trump. And we're also here because the Republican Party that's done such a great job over many years standing up for the police no longer back the blue. Last week, we had a hearing where you could call anyone in America when you have the majority, the power of a subpoena. We had a hearing about the ATF. These guys brought a witness who had just recently tweeted, "Fuck cops." Fuck cops. That's what this guy tweeted. Anyone on earth could have come to that hearing, and they brought someone that said, "Fuck cops." Then one of their colleagues, this is what she's selling on her social media: defund the FBI. So we went from backing the blue to backing the coup. So we'll waste our time today on this exercise on behalf of Donald Trump and perhaps Elon Musk. But everyone on their side is going to have to go home this weekend to their constituents. And their constituents are going to ask them one question. 3 little babies died this week at a school in Nashville. No other committee in Congress has jurisdiction to do something about that except this committee. So you're on the Judiciary Committee. 3 kids are dead. They're going to be buried this week. What did you do about it? Did you show up to the Judiciary Committee and fight for those kids? Or did you show up and fight for Donald Trump? They showed up the first hearing after Nashville, and they're fighting for Donald Trump. And I yield back.
Thank the gentleman. As I want to apologize to our witnesses because you may wonder, did I wander into the wrong hearing? No, this is the Subcommittee on Commitment and Accountability to Oversight, not the Weaponization Committee, as much as my ranking member would like it.
Mr. Chairman, point of order, unless you're going to give us a chance to respond
You're
to
not
your
recognized.
comments. We'll
We'll now introduce today's witnesses. The Honorable Christopher Dunham is the Acting Assistant Director for the Office of Congressional Affairs at the FBI. In that role, he leads the office that serves as the Bureau's primary liaison to Congress. Jean Bumpus is the Director of the Office of Congressional Relations at the Federal Trade Commission. Her office works with members of Congress and their staffs to provide information on the Commission's activities and advance the interests of the Commission in Congress. The Honorable Roberto Rodriguez. Mr. Rodriguez is the Assistant Secretary for the Office of Planning, Evaluation, and Policy Development at the Department of Education. His office advises the Secretary of Education on all matters relating to policy development, implementation, and review. We welcome our witnesses and thank them for appearing today. We'll begin by swearing you in. Would you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? All right. The record will reflect that the witnesses have answered in the affirmative, and thank you. You may be seated. Please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony in 5 minutes. Microphone in front of you has a clock and a series of lights. When the lights turn yellow, you should begin to conclude your remarks. When the light turns red, your time has expired. Mr. Dunham, you may begin.
Good afternoon, Chairman Klein, Ranking Member Swalwell, and distinguished members of the subcommittee. I appreciate the opportunity to describe the FBI's efforts to respond to the committee's oversight requests in the 118th Congress. I'm the Acting Assistant Director of the FBI's Office of Congressional Affairs. I'm here voluntarily to answer your questions. Unlike others who may come before this subcommittee, I'm not a political appointee, nor am I an attorney. I've spent the entirety of my professional government life in civil service of the FBI's mission. I agreed to serve as Acting Assistant Director several months ago. In this role, I lead a team of agents and professional staff who are dedicated to working with Congress on all manner of legislative, policy, and oversight issues. As long as I serve in this role, I'm committed to working in good faith with all members of the subcommittee and the full Judiciary Committee. The FBI recognizes the important role of congressional oversight. We appreciate that oversight is a critical underpinning of the legislative process, and we recognize that it can shed valuable light on the FBI's operations and stewardship of taxpayer dollars. Since 2021, the FBI has testified at 32 congressional hearings and participated in hundreds of member and staff briefings. By virtue of the FBI's dual law enforcement and intelligence responsibilities, we work closely with 8 congressional oversight committees of jurisdiction, including both House and Senate committees who oversee the intelligence community, and committees like this one who oversee the Justice Department. In every instance, we strive to provide Congress with information to support its legislative needs without compromising our law enforcement and national security efforts, including our investigative and prosecutorial responsibilities. The FBI must also consider the privacy and safety interests implicated in revealing the identities of our dedicated line agents and personnel. With these considerations in mind, we are committed to working in good faith to accommodate the committee's oversight interests. We understand the purview of this subcommittee is to oversee the responsiveness of agencies to the full committee's oversight requests. In this Congress so far, the committee has identified well over 50 informational requests across nearly a dozen different topics, in addition to requests for 19 transcribed interviews. The FBI is complying with the committee's requests in good faith. Since January, the FBI has provided 10 responses on 9 separate topics, including substantive written responses that provide critical information and context. We've also produced nearly 1,000 pages of documents with more to come. In addition, we authorized the appearance of a former senior FBI official for a transcribed interview last month before the committee. Today, we remain engaged and are actively responding to your other requests, including working to supplement our initial productions on a rolling basis as we identify additional responsive documents. Committee staff recently indicated that the committee is prioritizing, in addition to today's hearing, the scheduling of transcribed witness interviews. That scheduling is underway, and the FBI is working with committee staff to provide multiple requested witnesses for transcribed interviews in the next few weeks. Finally, we look forward to continued engagement with the committee, especially to discuss additional ways to prioritize remaining requests in light of our available resources and the committee's interests. And we remain optimistic that by working cooperatively, we will be able to satisfy the committee's legislative needs while also safeguarding the independence, integrity, and effectiveness of our law enforcement efforts. This, of course, is at the core of the FBI's mission, to protect the American people and uphold the Constitution. Thank you again for the opportunity to be here. I'm happy to answer your questions.
Thank you. Ms. Bumpus, you're recognized for 5 minutes.
Thank you. Chairman Klein, Ranking Member Swalwell, and distinguished members of the subcommittee. I'm Jean Bumpus, Director of the Office of Congressional Relations at the FTC. I'm here to address the FTC's responses to requests from this committee. The FTC shares your view that congressional oversight is vital to a well-functioning democracy. The Commission is committed to cooperating with the committee's efforts to seek information consistent with our obligation to protect the agency's ongoing initiatives and law enforcement efforts. And as a former Hill staffer, I appreciate that oversight is an essential responsibility of Congress and a critical aspect of the legislative process. The FTC works regularly with members and committees to provide them with expert, thoughtful, and timely information, irrespective of party or position. My office connects congressional staff with commission officials and subject matter experts to provide technical assistance on proposed legislation, coordinates responses to congressional letters, assists with efforts aimed at helping your constituents avoid fraud, coordinates the provision of information and briefings about the FTC's work and operations, and shepherds nominees through the confirmation process. On February 14th, Chairman Jordan wrote to the FTC requesting documents and information related to the Commission's recent issuance of a notice of proposed rulemaking on non-compete clauses in employment contracts. And we began working to reply. On February 28th, the FTC sent a letter and an initial production of documents to the committee. In that letter, the FTC answered numerous questions and made clear that it is committed to responding to the committee's document requests in a timely manner. A week later, the FTC provided additional documents. To date, we have sent approximately 1,400 pages of responsive material to the committee. FTC staff continues to reach out to committee staff to keep them apprised of our efforts and discuss how best to provide additional responsive materials. In addition, on March 10th, the agency received a request from the committee for documents connected to Mr. Musk's purchase of Twitter and any FTC investigation of the company. The Commission provided an initial letter response on March 27th, and we followed up with the committee staff earlier this week. On March 13th, the FTC received a letter asking that I testify today about the agency's responsiveness to the committee's requests. The FTC remains committed to working with Congress in good faith, consistent with long-standing Commission policy. The FTC looks forward to continuing to engage with your staff to comply with the committee's oversight requests while ensuring the FTC can continue to protect the independence, integrity, and effectiveness of its law enforcement efforts and core agency processes. I'm happy to answer any questions you have.
Thank you. Mr. Rodriguez, you're recognized for 5 minutes.
Good afternoon, Chairman Klein, Ranking Member Swalwell, distinguished members of this subcommittee. I am Roberto Rodriguez. I have the honor of serving as Assistant Secretary in the Office of Planning, Evaluation, and Policy Development at the U.S. Department of Education. Our role is to develop and implement policy, budget, and data across the department to improve student opportunity and outcomes. Although I'm pleased to advance our administration's policy priorities and budget before Congress, I'm here today on behalf of the department to discuss our document production and ongoing good faith effort to respond to this committee's oversight needs. Having served for 8 years leading the Democratic staff on the Senate Health, Education, Labor, and Pensions Committee, I have a deep appreciation for the important role that Congress exercises with regard to oversight to advance and uphold the efficacy and integrity of government. I'm pleased to share that the Department of Education has been responsive to congressional inquiries regarding the topics of interest before this committee for more than a year. This includes voluntarily appearing and testifying before this committee on Thursday, March 9th, transmitting 2 document productions totaling 1,335 pages, and engaging in numerous communications with committee staff. It is in that spirit that I am appearing before this committee again today, and that the department will continue to voluntarily engage with the committee about its informational needs. On January 17th, 2023, Chairman Jordan sent a letter to the Department of Education about 3 topics. First, Chairman Jordan inquired about a letter that the National School Boards Association sent to President Biden. Second, the chairman's letter asked about a Department of Justice memo. And third, the chairman's letter asked about an appointment to the independent, nonpartisan National Assessment Governing Board. Immediately, the department began to engage in the standard accommodations process with the committee, resulting in our February 2nd response expressing our readiness to work with the committee regarding its oversight requests. The next day, on February 3rd, the chairman served a subpoena to the department for documents. On February 13th, department staff communicated that a document production would be forthcoming by the March 1st date specified in the subpoena. On February 16th, nearly 2 weeks before the committee's requested production date, the department was called to testify about our response to the committee's inquiry. As promised on March 1st, the department transmitted more than 1,000 pages of responsive material to the committee. And on March 9th, Assistant Secretary Graham testified before this subcommittee regarding the department's response to the committee's requests. Just 4 days later, the committee again asked the department to return and testify regarding this inquiry, even while our staff were actively engaged and continuously providing further information to be responsive to the committee's requests. On March 24th, the department transmitted its second document production, consisting of 331 pages, and offered an opportunity for committee staff to view selected redactions in camera. Our ongoing engagement with the committee, multiple document productions, and willingness to appear voluntarily before this committee on multiple occasions demonstrates the department's continued commitment to working with Congress in good faith while ensuring that we fulfill our core mission of fostering educational excellence for all students across this country. Carrying forth that mission is important today more than ever before, as our nation continues its recovery from the pandemic, supports students' academic success and well-being, and works with local and state educational agencies to tackle pressing challenges, such as the teaching shortage that's facing schools, classrooms, and communities across the nation. While my colleague, Assistant Secretary Graham, was unable to be here today, I'm pleased to appear before the committee and respond to your questions about this process. Thank you.
Thank you, Mr. Rodriguez. We'll now proceed under the 5-minute rule with questions. I anticipate we'll have 2 rounds of questions today. Now recognize myself for 5 minutes. I'm going to take a moment to address some of the comments of the ranking member. You know, the chairman of this committee, this is not the January 6th committee. This is not the weaponization committee. This is about compliance. And as much as we want to have cooperation from the witnesses, compliance is what we're after. So at the end of the day, we want to see the documents. Now, as to the allegations made by the ranking member, the chairman, Mr. Jordan, never said that he wouldn't testify before the January 6th commission. I noted that you put up a letter. The letter actually was in response to a letter from Chairman Jordan about testifying. He said this multiple times in interviews. And the January 6th committee stopped negotiating with Mr. Jordan about potential testimony Every time the January 6th committee asked Mr. Jordan to testify, he responded. December 22nd, he responded January 9th. May 12th, they asked. May 25th, he responded. May 31st, they respond, renewing their subpoena. June 9th, Mr. Jordan sent another letter, and no response after the last letter from Mr. Jordan. So the chairman was very responsive.
Will the gentleman yield to
I will not.
answer whether
It's
he
my
actually
time.
testified?
It's my time.
Okay. Did he testify?
It's my time. Freedom of speech is among the most important rights guaranteed to every American. Elon Musk's acquisition of Twitter last year served to revitalize this fundamental freedom in the digital age. Now, in the wake of this acquisition, the FTC engaged in an aggressive campaign to harass Twitter and deluge it with demands about its personnel decisions in each of the company's departments, every internal communication relating to Elon Musk, and even Twitter's interactions with journalists. These demands have no basis in the FTC's statutory mission and appear to be the result of partisan pressure to target Twitter and silence Musk. The FTC is currently imposed some demands on Twitter that had no rational basis in user privacy. There was no logical reason, for example, why the FTC needed to know the identities of journalists engaging with Twitter. There was no logical reason why the FTC, on the basis of user privacy, needed to analyze all of Twitter's personnel decisions. And there was no logical reason why the FTC needed every single internal Twitter communication about Elon Musk. The strong inference from these facts is that Twitter's rediscovered focus on free speech is being met with politically motivated attempts to thwart Elon Musk's goals. The FTC's demands did not occur in a vacuum. They appear to be the result of loud voices on the left, including elected officials, urging the federal government to intervene in Musk's acquisition and management of the company. The FTC's harassment of Twitter is likely due to one fact: Musk's self-described absolutist commitment to free expression in the digital town square. So, Director Bumpus, on March 10th, 2023, Chairman Jordan sent a letter seeking information and documents about the FTC's investigation of their harassment of Elon Musk's Twitter. It demanded that Twitter identify all journalists and other members of the media to whom Twitter has granted any type of access to the company's internal communications, e.g. Slack, emails, resources, internal documents, and/or files since October 27, 2022. Your response, the FTC's response, was not timely and only barely responsive to the inquiry, with no indication when additional information would be provided. As the Select Subcommittee's report states, its approach appears to be the result of partisan pressure to target Twitter and silence Musk. When does the FTC expect to provide the information and documents requested in the March 10th, 2023 letter?
Congressman, as you noted, we provided a narrative response to the question posed earlier this week. We have reached out to staff. We would like to be responsive, and we look forward to connecting soon with the committee to talk about next steps.
It's well over 2 weeks since the FTC received Chairman Jordan's inquiry, and the FTC barely responded on substance to the inquiry. Can you tell me what accounted for the delay?
Congressman, we want to be responsive to your request. The Commission, while I cannot talk about non-public investigations, has confirmed that it is investigating compliance by Twitter with a consent order related to data security and privacy. And we look forward to continuing to engage with this committee to get you responsive documents.
All right, we asked you to testify today, and you initially responded that you would not and requested that the executive director testify. But can you tell me, are there topics or subjects about which you've been instructed or encouraged not to testify? And if so, what topics and who gave those instructions?
Not at all, Mr. Chairman. I've not been instructed not to testify about anything.
All right. Well, through the Twitter files, Americans are learning more about one of the most significant threats to civil liberties in the modern era. The executive branch's suppression of free speech is a real peril to our republic. And given the gravity of the situation, it was my hope that the FTC would provide the information necessary for this matter. I now yield to the ranking member for 5 minutes.
Thank you. And Chairman, what's interesting to me is that this hearing is about transparency. And my staff has told me that there are multiple documents that you have allowed my staff to look at in camera, meaning they can go look at them, but they cannot have them, documents that you've been given related to an FTC inquiry. And my ask is just that you turn those over to us. It sounds like we are asking you to do what you think these witnesses are not doing. So again, just in the spirit of transparency, we would like those documents. Mr. Dunham,
I'll take it under advisement.
thank you, Mr. Chairman. Mr. Dunham, following the subpoena you received from the Judiciary Committee Republicans, you offered to meet and confer with them on multiple occasions. Is that right?
We met with the committee in early January on the initial forming of the committee in the new Congress, and then we've had several engagements or outreach since the subpoena.
And what would happen if you violated a subpoena and just didn't show up?
I'm not sure what the consequences would be for me, but we're actively engaged with the committee and intend to do so going forward as well.
Great. Well, thank you for doing what Jim Jordan wasn't willing to do and show up and be responsive. Your good faith effort did not end there, though. In fact, you also offered to work with them to prioritize their document requests. Is that right?
When we received Chairman Jordan's letter on January 17th, we also had a meeting previously scheduled that afternoon with committee staff, more as a meet and greet to kind of talk about the 118th Congress and discuss the topics of interest to the committee to determine what was the primary focus of their interest.
And in addition to that meeting, you allowed them to come in person and review non-public documents. Is that correct?
In response to the subpoena, we provided in-camera review of Guardian documents related to the EDU official tags, which was a substantive production at the core of the subpoena's request.
And these guys viewed those documents?
The documents were reviewed by both majority and minority staff.
And after viewing the documents, and do those documents, by the way, include what we call law enforcement sensitive information?
The documents themselves are law enforcement sensitive. They're law enforcement files. They're tips that we receive from the public and the actions associated with those tips. So yes.
What's the difference between something you call law enforcement sensitive and something that you could put on the front page of the Washington Post?
Something that's purely unclassified versus something that has a law enforcement caveat that is necessary to protect potential investigative equities, witness information, subject information, anything related to sources, methods, techniques, that type of thing.
And after Jim Jordan's team viewed the documents, are you aware of a report that Jim Jordan drafted related to their inquiry?
I'm aware.
And in that report, was it a public report?
I believe it was a public report.
And in that report, did you see any law enforcement sensitive information?
I'm not aware of what information was in the report. I haven't studied it closely enough to determine whether there's law enforcement sensitive information there, but that's something I can certainly get back to you on.
Okay, I'll go back to you with some pieces that we saw that were included in there that would qualify as an unlawful disclosure. Ms. Bumpus, thank you again for also doing something that Jim Jordan would not do and responding to a subpoena. Is it true that you've worked for multiple prior chairs that were Republican and Democratic and even worked for John McCain when you worked on the Hill?
Sorry, yes, Congressman. I did work for John McCain on the Hill prior to coming to the FTC in 2006, and I've worked for 8 chairmen as Director of Congressional Relations for Democrats and for Republicans.
And while you were responsive to the inquiries of the chairman, is it true that you cannot provide information about ongoing or potential investigations?
That is correct. Under the rules of the commission, we cannot disclose non-public information without a vote of the commission.
So would you be committing a crime if you did what Jim Jordan is asking you to do?
I cannot speak today about non-public information or about ongoing investigations.
Thank you. Yield back.
The gentleman from New Jersey is recognized for 5 minutes.
Thank you, Mr. Chairman. I hate to waste time, but I have to start out because this falls under the policy. If you say things over and over and over and over again, people will start to believe them. Let's hear the truth. Let's know what the truth is. Mr. Jordan, our chairman, told CBS News on January 13th, 2022, that I never said no. He never said no to testify before the January 6th committee. And here's a direct quote. And we have it, and I'd like to enter this into the record, Chairman, this direct quote. "There's a reason I was concerned about testifying, but I never said," and this was on CBS, "I never said no." And that was to Major Garrett.
Without
I'd
objection.
like to enter that. Thank you. So I don't know if I should say it again. Would that make everybody believe it more? Because Mr. Swallow thinks that by saying it over and over and over and over and over again, I put a lot of overs in there, Eric, just like you do when you speak, you know, or by using the F word when we really didn't need it in the testimony in the hearing. We could have done that in a quite a more gentle way, but it's sensational. It's sensational. And certainly, Mr. Swalwell, this hearing's not about you. I know it's been made about you to some degree, but you're a sensational guy, and you've been involved in an awful lot of things that are pretty amazing and questionable, but we're not here to discuss them today because that would be exciting testimony. We're here to discuss, number one, Jim Jordan, if you want to keep bringing it up, and January 6th. And by the way, I wouldn't blame him that he doesn't want to testify, but he said he would, because the January 6th committee wasn't bipartisan. It wasn't formulated right. It didn't have any real members on there that were appointed by the minority leader at that time or anybody from really any substance of the Republican Party. The bottom line was it wasn't a real committee. It didn't tell the truth. It didn't do the right thing. Now, do you want me to say that over again? It wasn't the right committee. It didn't do the right thing. It didn't tell the truth. Do you want me to say it over again? It wasn't a good committee. It didn't do the right thing, and it didn't tell the truth.
One more time.
One more time? It didn't tell the truth, okay? So I can repeat things a lot too, and it wastes time. But you know, you never let the truth get in the way of a good story. And Mr. Swalwell, I'll say this. I don't know if you've ever seen the show Seinfeld. Jerry Seinfeld, remember that show? Some of us are old enough to remember it, and some of us just like it. And they asked George one time, because he was going to tell a big, fat, whopping lie. And he said, well, the truth is the truth if you believe it's the truth, even if it's a lie. Mr. Swalwell, I believe that's the deal in what you're doing here, and I'm sorry, but sorry to have to say it to you, but that's what I think. Mr. Dunham, thank you for coming in today. Can I ask why the FBI wasn't present at our previous hearing?
Yeah, thank you, Congressman. First, I'd be remiss if I didn't mention I was born in Carneys Point. I got a lot of family in South Jersey
God
that
bless
are your
you.
constituents. So
Salem County.
Beautiful territory down there, love it. I was with the director. He was testifying before the House Permanent Select Committee on Intelligence for the annual threat assessment hearing. I had conversation with the staff in advance of your March 9th hearing.
Please excuse me, I don't mean to be rude. Why didn't they just show up? Isn't it so much easier? It's, you know, like everything else. Why not just give us the documents? Why not just show up? You know something's wrong. Intuitively, something's wrong. And you know, again, Mr. Swalwell asked, what are the American people? They know something's wrong. Over 60% of them know that it's not right. I love the FBI. I want to trust the FBI. And I don't understand some of the things that are going on now. And I don't understand why he wouldn't be here at this meeting. He should have been.
I appreciate the flexibility of the committee allowing me to come at a later date, and I'm here today to answer your questions.
Thank you for doing that. You know, and by the way, you know what I'm going to do? And I know it's going to aggravate them a lot. I'm going to talk about Mar-a-Lago again. Everybody ready? Because we can say over and over and over again, it doesn't matter. It has nothing to do whether you like Donald Trump or not. You know why it matters? It matters because dozens of FBI agents descended upon Mar-a-Lago where there was a former sitting president who had Secret Service around him. Were they afraid of the Secret Service? Is that why they needed so many arms? Did they think Donald Trump was going to come out and he was going to start shooting it up? What was the reason, especially when there was cooperation, especially when it was done with our current president who had somewhat of a similar situation, and this didn't happen? So I have the answer to you. Why do we need so many people? Why did we have to be so violent? Why do we have to be so aggressive?
Gentleman's permitted to answer.
I think, Congressman, as you're aware, there are multiple special counsel investigations looking into not only the Donald Trump, former President Trump documents, but also the Biden documents as well. And I would defer you to the Department of Justice for questions related
It's
to that.
not an
but-
answer. I'm sorry, and I love you from Carney's point, but it's not an answer.
Gentleman's time has expired.
I'd be
Gentleman
happy
from
to answer the
Maryland
question.
is recognized for 5 minutes.
Thank you. The reason they went in after Donald Trump differently than they did with President Biden or Vice President Pence, as we discussed at the last hearing, this is like Groundhog Day, was because Trump hid documents and didn't comply with the subpoena that he was given. And he actually, apparently his lawyers lied on his behalf because he lied to his lawyers. And that's why that lawyer had to testify, was ordered to testify by a judge last week. So, and on the Jim Jordan piece, which we also did at the last hearing, okay, he never said no, but of course we know he never said yes because guess what? He never testified. I've got an article here, it's by Luke Broadwater with the New York Times. It's entitled, Jim Jordan Refuses to Cooperate with January 6th Panel. I'd ask for unanimous consent to have it admitted into the record.
Without objection.
With respect to the Jordan response, which, again, we did it last time. I didn't know I was going to have to do it again, but let me just read it into the record. They requested material from Jim Jordan in the form of a subpoena, I guess similar to what you just got. But in response, rather than just produce documents like all of you have and produce letters saying, we look forward to complying and offer to meet with you so we can make compliance work, Jim Jordan sends a request back saying he wants all of the materials referencing him in the Select Committee's possession and all internal legal analysis related to the constitutionality of member subpoenas. Now, if you all did something like that, they'd send the cavalry after you because that's clearly a non-compliance. And not only that, it's about as close to saying a direct no as you can get. So we can go through this, but it's clear Jim Jordan never testified. He never intended to testify. There are others who didn't as well. Speaker McCarthy didn't testify. Congressman Perry didn't testify, on and on and on. But you're being held to a different standard. And the standard you're being held to is unreasonable. Let me just say it that way. You've done everything, I think, to comply. Your compliance would be totally acceptable in a court. And the reaction of the committee coming after you, like a subpoena the day after you responded, is outrageous. And I gotta say, the second hearing too, even in the face of your ongoing compliance, is a complete waste of time because they're doing everything to comply that they would be expected to. In my view, this committee really ought to be doing different things. I've got, earlier today I was at a press conference about the Nashville shootings. The Judiciary Committee has jurisdiction over gun violence, is choosing not to exercise it. Republicans are choosing the Second Amendment over second graders. They're talking about banning books instead of banning assault weapons. They get the right to do that, but it's really time for us to get focused on real things. These investigations they're conducting, the weaponization committee they created, rather than deal with real weapons that we've got on our streets and in our schools right now, is another complete waste of time. And by the way, there was a reference to the public thinking this is good stuff. It's actually quite the opposite. The public has already started to recognize that these hearings, these so-called investigative hearings, which are chasing after nothing, the American people recognize that this has nothing to do with the things they care the most about. They're worried about the economy. They're worrying about getting guns out of our schools. I think we've had 127 mass shootings just this year alone. And our response from the Republican side of the aisle is total silence on this. We get thoughts and prayers, but as Paul wrote, faith without works is dead. So I hope that we can get focused on two things. If you're going to stay on this track, let's be honest about what's going on here. The chairman mentioned in the face of continued obstruction, there's no evidence of obstruction here. There really isn't. In fact, the in-camera inspection that was done, I think was at the recommendation or the offer of the minority staff. And then after the inspection was done, apparently some of this information got leaked out. So could be just a coincidence, But I got to say, next time this committee comes and says we want to see what you redacted, that's got to be in the minds, and appropriately, of these people who run the departments, especially when they're dealing with sensitive information, and whether it's ongoing investigation, sources and methods, or whatever. And certainly grand jury material, it's important for that front too. So I yield back my time, but I sure do hope we can get focused on things that really impact the American people.
Gentleman's time has expired. Mr. Moran is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Rodriguez, I want to direct my questions to you. Thank you for taking the time to meet with us today. At the last meeting, as you know, Secretary Gwen Graham was here to discuss the document production issues, and she pledged to meet immediately with staff and those involved in production to discuss the production supplementation that was needed and also the redaction issues that came up at the last hearing. I want to ask you, were you part of that meeting, Mr. Rodriguez?
No, sir, I was not.
Have you met with Ms. Graham to discuss what she pledged to this committee last time she was here? And if so, what did you guys talk about?
I'm aware of her commitment, but we did not meet to discuss that further.
All right. What preparation did you have between last meeting and this meeting to prepare for providing additional supplementation to what she testified to?
Well, sir, I have spent hours preparing for this hearing and to be able to answer your questions. And I know our staff have met, I believe, on 3 occasions over the last few weeks to further discuss some of those redactions.
In your preparation, did you look through that 1,000+ pages that have been produced?
Yes, sir, I did.
Did you look at them in unredacted form?
I also reviewed some of those, not every single line.
Okay. Let me show you what was just handed to you. I'm going to reference it. It's a list of 26 different documents by Bates number, starting with number 1, base number HJC 118, 16, all the way down to number 26, HJC-118, 850. It's a series of 26 sets of documents that this committee has prioritized and asked you to produce, at least in camera, without waiving the ability to see them in full and unredacted form for the committee itself. The committee staff is asked to look at these in unredacted form in camera. Only 2 of them have been offered to be put up to do so. Do you know why it's only 2 and not all 26?
Sir, I do know that we are continuing our work to provide additional documents for the committee's review. I believe there will be a third package as well of documents.
Is that third package going to be unredacted copies of any of these 26 that's referenced on this page?
I cannot speak to the particular planned redactions or lack thereof for this next package. I do know that there are the 2 first and second document that have been prioritized per discussions with this committee to be made available on camera.
Are you able to testify about why any of these documents on this list of 26 has been actually redacted?
Well, I can speak, sir, to the process of redaction, which is consistent with longstanding process at the U.S. Department of Education across the course of multiple administrations and with executive branch confidentiality interests. And so those redactions may be based on deliberative process, attorney-client privilege, personal information. I can say that many of those documents contained internal confidential communication, but the department remains ready to...
Let me stop you there. Can you be more specific when you say internal confidential information? What do you mean by that, other than personal information or attorney-client privilege or the deliberative process privilege?
Sir, I mean those 3 things.
Okay.
Sorry.
So is it your testimony that some of these documents on this 26 actually contain attorney-client privilege?
Again, I can't speak to this list of 26 documents, only to the first delivery of the package, and to say that we remain ready and will continue to meet with this committee to provide further information in response to specific interests.
So who
relative
can,
to those
I'd like to know
redactions.
who can actually tell me which privilege that you're asserting applies to which document?
That would be a process to continue in the conversations with this committee, right? I know our staffs have
I get that, but you're not answering my question. Who is it that we can sit at this table to ask that question as to why these documents are being redacted and why this committee staff is not being able to see them in camera?
I'm happy to take that question back, sir.
When can you get me an answer about that?
I will take that back and commit to getting back to this committee after this hearing.
And you're going to be able to give me a specific name of a person that can tell me the specific reason why each of those documents is redacted. Is that what I hear you saying?
I'm happy to take your request back and to continue, and to commit to our department continuing to work with this committee on a case-by-case basis relative to specific redactions that the committee is interested in seeing.
You've mentioned a lot about, or you mentioned some about the deliberative process privilege. Are you able to tell me what the common law elements are to assert that privilege?
No, I'm not able to speak to those technical questions today. I can take those questions back for further discussion.
Well, just for information, it's got to be pre-decisional and it's got to be deliberative. Those communications must meet those two substantive elements. If it doesn't meet those two elements, it doesn't qualify for that privilege. Now, there is some argument to say that privilege doesn't apply at all, but assuming it does, even at all, it's got to meet those two requirements. And I would urge you and your colleagues to go back and look at each of these documents to make sure that you can, in good faith, say it does in fact. Because we're going to get to the bottom of these at some point, and we're going to come back to the testimony you're giving in this hearing today, and we're going to understand whether or not that privilege is being asserted correctly or not. And in fact, it hasn't been officially asserted, I'll just tell you. It hasn't been asserted at all, except in the committee room, which is not the appropriate place. It must be in writing, and it must be done before the subpoena deadline was to be responded to. So I yield back.
Thank you.
Gentleman can respond if he wishes. Well, let me just put it this way. I think the long and short of what the gentleman said was the more we get, the less likely you're coming back. But the less we get, the more likely we're going to see you again. The gentlelady, Ms. Lee, is recognized.
Thank you, Mr. Chairman. And Director Dunham, I would like to direct my questions to you. On January 13th, 2023, the FBI's Richmond Field Office published an official document that linked radically or ethnically motivated violent extremists with what the FBI referred to as radical traditionalist Catholics. This proposed targeting of Americans practicing their faith necessitates oversight by Congress and raises serious concerns about Americans being able to freely exercise their religion without having unlawful surveillance conducted by agents of federal law enforcement. And as somebody who spent many years working alongside the brave men and women of the Bureau on the local level, we also here want to ensure that the FBI is directing its resources and its attention to helping protect our communities and keep our communities safe, as opposed to an undue or unwarranted focus on surveilling particular religious groups. So with that, is it correct to say, Director Dunham, this committee in fact sent a request for information to the Bureau on February 16th, 2023?
I believe that's correct.
All right. And in response to that request, to this date, the Bureau has produced 18 pages of documents. Is that right?
I think that's accurate.
All right. Among other things, this committee requested a list of the FBI investigations, local law enforcement agency reporting, and liaison reporting with varying degrees of cooperation and access that the FBI's Richmond Field Office relied upon to make its assessments. Have those documents been provided to date to this committee?
We've not provided those documents.
When will those documents be provided?
I don't have a timeline for you yet. In my letter that we sent last week, I mentioned that there's an internal review going on to get to the bottom of a lot of these issues that you referenced, and I anticipate having ongoing dialogue with the committee and with staff, and we'll be able to provide more information once that review is complete.
And Mr. Dunham, are you personally engaged in that review process?
I'm not.
Who at the FBI is engaged in that review process?
I'll have to take that back. I believe it might be through our inspection division, but I'll get back to you on that.
And to this point, has the inspection division given you a date by which they will be producing these documents back to us?
I don't have a date for you, but I'll get back to you on that.
All right. Is it also correct that this committee requested a list of FBI employees involved in the drafting, reviewing, approving, or disseminating of the January 23rd, 2023 domain perspective entitled Interest of Racially or Ethnically Motivated Violent Extremists, Radical Traditionalist Catholic Ideology? We made that request to you as well. Is that right?
That's correct.
And to this point, have documents been provided in response to that request?
We have not.
When will those documents be provided to this committee?
That's something that I'll take back and I'll get you information on. What I'll say is that some of that information may contain what we call non-SES employee information. That's something that through practice and policy we're more protective of our employees to avoid having them become targets of our adversaries for intel or operational purposes, to avoid them becoming targets of harassment, to avoid any limitations they may have. It's been the FBI's position that decisions that are made are best reflected, explained by the executives who direct those decisions. I
And
anticipate
certainly
having.
the FBI is capable of distinguishing between particular sensitive information it feels it needs to protect and that information which is something that is appropriate and necessary for us to engage in oversight, correct?
Agree with that.
And there are also multiple methods for producing and providing information to us that we've heard about, even during the course of this hearing, that could achieve both objectives of protecting the necessary identification information for agents who are out working in the field, but also ensure that as members of Congress, we have access to these vital documents to conduct our oversight, correct?
Correct.
All right. Now, the Bureau's interest in this potential threat appeared to be increasing as there was an upcoming election. Can you elucidate for us why it would be that this particular subject was something that became of interest to the FBI as an election was approaching?
I'm not a subject matter expert on this topic. I don't have any inside information on the product. I think the Attorney General and the Director have been clear in their testimony when asked about this, that the product did not meet the FBI's exacting standards, and it was unacceptable, and that's why we're looking into how it came to be.
All right. Thank you, Director Dunham. Mr. Chairman, I yield back.
I thank the gentlelady. We'll start round two. I want to start by, just for the record, noting in response to some of the ranking members' allegations about sensitive material being made public, that the information that he alleges was improperly made public was actually provided by a whistleblower, and that information was made public legally and under a May 11th letter and a November 4th report.
Will you give us the whistleblower notes?
I'll take that under advisement. Let me go back to Ms. Bumpus. Ms. Bumpus, it's been well over a month since the committee's oversight letter about the FTC's rulemaking on non-compete clauses was sent, and explained in that letter the FTC lacks legal authority to promulgate this rule and is also running roughshod on federalism in a well-established area of state law. On February 28th, the FTC provided a written response and only 43 pages of notifications that schedule a variety of meetings. On March 7th, over 3 weeks ago, the FTC made a production of around 1,400 more pages of materials, but of that production, only about 100 pages were not already publicly available, and none of them have provided any insight as to the internal discussions that have led to this radical proposed rule. Understand that the FTC has said they'll produce materials on a rolling basis, but it's been more than a month since the FTC received this oversight letter and 22 days since the last production. When does the FTC expect to complete its production of responsive documents?
Thank you, Mr. Chairman. I can't tell you when we expect to complete it. I can tell you that we're continuing to work on it, and we expect to make another production in April. We've reached out to your staff, and we hope to engage with them to learn more about your priorities.
Well, it's well known that the FTC frequently seeks extensive information from private parties that it investigates. When those parties fail to produce what's required for the FTC to conduct its investigation, the FTC also seeks sanctions. In the FTC's response to this inquiry, most of what it's provided is already publicly available or otherwise incomplete. I find it quite remarkable and inconceivable that the FTC would tolerate such a production from parties under its own investigation. What should the committee take from the FTC's paltry production to date on this important matter?
I hope the committee takes that we respect your oversight authority and that we'd like to be responsive, and we will look forward to continuing to work with you to get there.
In its letter in response to the committee's oversight of the FTC's proposed non-competes rulemaking, the FTC said that a CFPB employee served a detail to the FTC and worked on the rulemaking. This CFPB employee, quote, led the team on a daily basis. He supervised the drafting of the Notice of Proposed Rulemaking, ensured versions of the draft NPRM were circulated to the team and bureaus for their review, ensured versions of the draft NPRM were circulated to the Commission for its review, and oversaw any necessary legal research, end quote. This is an interesting and troubling development. It raises questions about former Commissioner Chopra's outsized remaining influence at the FTC. It is well known that Chair Khan was on Rohit Chopra's staff, and she gave jobs overseeing the competition and consumer protection missions, as well Chief of Staff and Chief Technologist to Rohit Chopra's other staffers. Now we are learning Rohit Chopra's influence continues as he has assigned one of his CFPB employees to a detail at the FTC, and that employee has led and supervised the FTC's non-compete rulemaking effort. The committee has questions related to the FTC's decision to staff this rulemaking in this way. However, for you, as the Director of the Office of Congressional Relations who coordinates the FTC's responses to our inquiries, let me ask, did the FTC take any steps to coordinate your response to this committee's with the staff at the CFPB?
Not that I'm aware of, Mr. Chairman.
When you helped coordinate the production to the committee, did you raise the issue that additional searching would need to be done at the CFPB?
I wasn't involved in the production itself. I don't know.
Former Commissioner Rohit Chopra is the director of CFPB. Has your office been in touch with him about responding to the committee's request?
I have not been in touch with him, and no one in my office has.
Who at the FTC is supervising the CFPB's employees' leadership on this issue? I'd like a name.
I'm not sure I understand the premise of your question.
Who at the FTC is supervising over the CFPB, this specific employee's leadership in this area? Do you know of the employee that of whom I'm speaking?
I believe the employee you're talking about was employed in the Office of Policy Planning.
Okay, and who is the head of, or who was supervising that official in policy and planning?
I believe the current head of the Office of Policy Planning is Elizabeth Wilkins.
Okay. In your experience, how common is it for the FTC to rely on staff of another federal agency to lead its teams on a daily basis and supervise drafting of rules?
I don't know.
What other interaction does your office or the FTC have with the CFPB that this committee should be aware of?
I'm not sure of the extent of our interaction. I know that both of us agencies are charged with consumer protection, so I would assume that there would be interaction, but I can't characterize the amount of it.
Okay. I just want to note that even in the limited materials that were provided, we can see that the FTC staff communicated using a staffer's personal Gmail account. And in other instances, the employee was using the employee's CFPB account, and other CFPB employees were using their CFPB accounts to communicate with the FTC on this matter. I yield to the ranking member for 5 minutes.
Ms. Bumpus, isn't it true that you all at the FTC had a consent decree with Twitter in 2011 and May 2022, well before Elon Musk bought that company?
That's correct.
And those consent decrees allege that Twitter had been reckless with consumer data. Is that correct?
I don't want to characterize them, but they dealt with the company's practices with respect to data security and privacy.
And Mr. Rodriguez, which committee in Congress has jurisdiction over the Department of Education?
That would be the Education and Workforce Committee and the Senate Help Committee.
That's not the Judiciary Committee? You didn't name them?
That's correct, sir.
Okay. So you could argue that requests that Virginia Fox has on the House Education Committee from you have to be balanced against requests that you have from a committee that's outside your jurisdiction. Is that right?
I am here to provide this committee the information that it needs, and we endeavor to balance all of our congressional requests.
Great. Well, I hope this side cleared all of this with Ms. Fox, because on our side, people would be pretty pissed off if you started going into another committee's jurisdiction, knowing that Leg Affairs only has so much bandwidth. But here's, well, I thank the witnesses. I'm sorry you had your time thoroughly and exhaustively wasted here today. I would like to enter into the record Jim Jordan's testimony to the January 6th committee. He didn't testify to the January 6th committee, is what you're about to say. And actually, that's the point here, is that there's no credibility. There's no credibility on Jim Jordan's committee to obstruct justice. He can't talk credibly about witnesses not complying with subpoenas, and that's why he's not here. He wasn't at the last hearing. He often goes to subcommittee hearings. This is one of the only ones he doesn't go to. It's because there's no credibility. You can't ask people to comply. You can't complain when people don't comply when you are 321 days into your own non-compliance. Just doesn't work. So he won't come here. He'll ask my friend, Mr. Klein here, who's doing his best job to represent Mr. Jordan, to do that instead. But Mr. Jordan won't come here. Mr. Jordan will pull the old, I don't have my reading glasses trick when he's asked if he will condemn a threat of death and destruction by the former president. Mr. Jordan, and actually no one on this dais, on the other side, will condemn Donald Trump posting a picture of himself with a baseball bat next to an African-American independent prosecutor. My colleagues continue to want to focus on Mar-a-Lago, and there's so many questions about the Mar-a-Lago search warrant from my colleague from New Jersey. That's not even the focus of this hearing. But we learned zero today about what their allegations were. I would actually say the only earnest questioning came from Mr. Moran and Ms. Lee, who had real questions, but everything else was on behalf of Donald Trump. And that's what we're going to continue to see from this side, is litigating on behalf of just one client, Donald Trump. And their credibility is in a free fall. And the attacks on law enforcement continue. Right after the Mar-a-Lago search, Mr. Dunham knows this, a madman with an assault rifle went to an FBI field office. Thankfully, he was killed by brave agents at the Bureau. But the attacks from this side on law enforcement are only going to bring more attacks on law enforcement. And I say that as someone who has two brothers who walk the beat. When you bring witnesses in this building, in this room, who tweet out, "fuck cops," what do you think's going to happen? People are going to take up violence against the cops. Those were your witnesses. You brought them here. When you have a colleague that you don't condemn who says defund the FBI, and you're silent, and you let that happen, people are going to go after the FBI. And so we'll waste more time, and as Mr. Ivey pointed out, more kids will be victims of gun violence, and the committee that can do something about it will focus on this nonsense. But I know where Mr. Ivey and I are on the issue of gun violence. We're going to continue to stand up to protect kids. It's clear that these guys are only here to protect Trump. And I yield back.
Gentleman from New Jersey is recognized for 5 minutes.
Well, I would say that the ranking member has made it clear, but what he's made clear is that he's going to use gun violence as a political tool, and that's unfortunate. And it's unfortunate to keep taking these children and their families and running them through the political gauntlet because you want to gain some points with it. That isn't the point of this committee. You know, I have questions. The first question, I want to thank Congresswoman Lee for bringing this up. It's okay to be Roman Catholic, right? Somebody answer me, please.
Yes.
Okay, I was getting a little nervous. I'm Roman Catholic, so
I'll say yes.
It was okay.
Yeah.
Okay. What is radical Catholic ideology? Why were we looking into that? What's that about?
I'm not able to speak to specifics of the actual product. I think that's what the internal review that I referenced earlier is getting.
Doesn't that concern you?
Certainly,
I
I
mean,
agree with the director's statements that the product was inexcusable.
Yeah, it sure was. What would ever lead anybody to think that they could start investigating that? Now, I'm not as good as I should be. I miss Mass sometimes, but mostly Mass is a very peaceful thing where people go and pray and get Holy Communion? What are we investigating? How did that ever get through at all to even get started? Why did it have to be condemned when it never should have happened? And I just want to say something else, too. Since Mr. Jordan was brought up again, I really hate doing this because we do have more important things. When Mr. Swalwell stops, I will stop. Again, here's his quote. "There's a reason I was concerned about testifying, but I never said no." And this is a quote that is recorded. It is part of our hearing. It is part of the testimony. The chairman has accepted it, and he has said that numerous times. Now, concern with testifying, I'd be damn concerned in testifying in front of that committee. That committee was a rigged committee. That committee didn't tell the truth. That committee was a political tool and nothing else, and it was shameful that Congress was used in that way. That committee was in nobody's mind or nobody's sense bipartisan. So Mr. Jordan didn't do anything wrong. He's always everywhere, and yeah, I will defend him. I think he's a damn good member and a damn good chairman and doesn't deserve that. But nevertheless, if we've got to say it over and over again, I'll say it over and over again. Just like I've said, if you all have to come over and over again, and you probably huddle together at the beginning of the day and say, all right, who's going to have to put up with it today, and decide who's going to go. And I feel bad that you have to go through it, but you do, because all we need is the information. If we get the information, we won't have to go through this process. But all I heard today is, I can't speak to the redaction. I can't tell us why we aren't given access. I'm not aware, not sure, I don't know. I don't know why it's so long. I don't know about the rule of law in this case. Have to take that back. Have to take it back. We know no more. I'm going to end this today in a similar way to when I ended it the last one. We know virtually no more now than we knew then. You don't have the documents with you, right? Correct? You do not have them? Did somebody answer that? Mr. Dunham, you don't have them. Ms. Bumpus, you don't have them. Mr. Rodriguez, you don't have them. I assume you didn't lose them. Correct? Am I correct in my assumption? Would please somebody answer me?
You want me to answer that one
Yeah.
too, or?
Yeah, I'd like you all three to answer. I mean, it's a pretty easy question. God help us, I hope it's an easy question. Because if you lost them, I'd understand what happened.
We are actively engaged in providing additional information to the committee. We've made 10 responses to the committee since the January 17th letter, including productions totaling nearly 1,000
But
pages.
you don't
And
know
we-
what it's going to be. Why can't we just get all the information, get it done, look at it together if you don't want us just to have it, learn what really happened? We know things happen here, that things went awry. We just do. You want to talk about the American people? The American people know something is wrong. They know something went awry. They know something is wrong, and they just want to get answers, no more or less than we do. We don't want to go on these tangents, but if other people do, we will. Who at the FBI made the decision to not comply with these requests until a subpoena was actually issued? Can somebody tell me that?
I'm not sure there's a sole decision maker there. We weren't aware of the school board request until we received the subpoena. We were operating under the January 17th Chairman Jordan letter as our prioritization list to get information to the committee for the 118th Congress.
So nobody's sure. Did the FBI only begin complying with the committee's various questions on February 3rd? Were we complying before then? And is the way, and I'm, it's the elephant in the room, and it's my last question, and I'll yield back, but are the way that Republicans are treated different in any way than the minority, as when we were the minority, as Democrats? Is that any difference when the Democrats were the majority and we were the minority? Any difference in the way we're treated?
There's absolutely no
you would
difference.
swear to me under oath that there's no difference.
There's absolutely no difference, Congressman. We provided responsive information on the 117th, and that was through the form of written materials, briefings, testimony before the full committee, proactive information that we provide the committee on a routine basis.
So then you would swear under oath, all three of you, that the information that we have is no more or less than the information.
Point of
they
order,
have.
Mr. Chairman.
The witnesses may answer.
I'm not aware of any difference in how we operate our practice and policy. It's consistent.
Thank you. I yield back.
The gentleman from Maryland is recognized. for 5 minutes.
I mean, it's hard to know where to start with all of that. The gentleman's comments about losing the documents. Now, I also said on Homeland Security, it's a little ironic because Democrats on Homeland Security have been trying to get the IG at the department to come give us information about the loss of the January 6th information by the Secret Service with respect to text messages on January 5th and January 6th. Our Republican colleagues to date haven't been helping us in accomplishing that. So, but there's no evidence of loss of documents here. The chairman mentioned something about the FTC. When you seek information, if you don't get it, you go to sanctions. I do want to point out that there's a lot of intermediate steps that courts require to be followed that this committee has not followed before you get to sanctions. And if you go to sanctions or request sanctions too soon, sanctions get imposed on you. So for example, in this instance, some of the subpoenas I looked at struck me as overbroad. They could have moved to quash. They would never do that to this committee out of respect for the House, but that's certainly something that could have happened and probably would have happened in the private sector. Overbroad request, no deficiency letter from the committee back. Hey, we're missing this in writing. And also, as I mentioned before, the duty to consult. There have been some consultations, but usually that's been the outreach of the departments to the committee as opposed to vice versa. And issuing a subpoena the day after receiving the letter, I thought was just over the top. The comment about, on a separate topic, mentioning gun violence means, quote, these children and their families are being dragged through this again, was particularly striking. Just last week, we sat in this hearing room with families of gun violence survivors, listening to a hearing. They were trying to, this is the bill that was going to overturn the ATF restrictions on the shoulder straps. And, you know, they were here because they want to be here. They were here because they want something done about gun violence. They had children die, and that's why they showed up. Same families that showed up, or actually same types of parents that showed up a couple of hours ago on the steps of the Capitol. They had children that were killed. They had classmates that were killed. They're not unhappy about us bringing this up. They're there because they want us to bring it up, and they're bringing it up too. And in addition to bringing it up, it's really time to do something about it. The Republican response to gun violence, as Mr. Jeffrey said a little while ago, is basically in the witness protection program. Nobody can find what it is. And there's an effort to try and hide it behind these kinds of hearings that they don't have a response to gun violence or, many of the issues that they complain about. But the time's come to put up or shut up. With respect to the budget, with respect to funding, I've got the Vox article here. The gentleman mentioned something about the American people want this. This is by Christian Paz. Quote, the House GOP's investigations are flopping. That's the name of the article. So the American people see through this. They want us to do things that really impact their lives. This hearing, which is essentially kind of an enforcement hearing on a subpoena, which a judge wouldn't bother with. He'd say, you guys go back and figure this out, which is what we should be doing here, which they've offered to do. And, trying to work this out in a committee hearing when we don't sit down with the people who actually do the work and make the decisions and can go through the redactions that you want us. Let's go meet with them. Let's do it that way. Let's get it done instead of wasting time at the hearings like this. And then the last point about concern about testifying. Mr. Jordan didn't show up because the January 6th committee was stacked and unfair to Republicans. I just want to remind everybody here that almost all of the witnesses that testified at the January 6th hearing were Republicans. In fact, one of them was President Trump's daughter. One of them was former President Trump's son-in-law. One of them was former President Trump's attorney general. They weren't too scared to go testify. They went, they got subpoenas. Some of them actually just complied voluntarily. They went and testified. Mr. Jordan didn't, the speaker didn't, others didn't. So let's not pretend like there was some scary trap that was being set. They just didn't go because they didn't want to go. And that's basically what's going on here today with respect to this hearing. Let's not hold them to a higher standard that we hold ourselves, because that's exactly what this hearing's about. And with that, I yield back.
Thank the gentleman. I'll note to Mr. Dunham, I was reminded that in the last hearing last month, the representative from the Department of Justice did concede that members of the minority were responded to differently than members of the majority. And so while the FBI may have a different policy, the Department of Justice apparently responds to members of the majority while ignoring members of the minority's requests often.
Would the gentleman yield? Because we discussed this last time.
Go ahead.
Okay. Well, the majority, under our committee rules, has authority to get responses that the minority does not. Now, if you were agreeing today that we can get that same authority, I appreciate it. We'd love to have that, not just with respect to this hearing, but other hearings that we want to go forward
And you
with,
just
like the
made
one I
my
just
point.
mentioned.
You just made my point. There's a different treatment for the majority and the minority, but I just wanted to caution before, as he answers the question. The
These were
gentleman
the-
from Texas is recognized for 5 minutes.
These were the rules that you all proposed and you voted in. Very well.
Thank you, Mr. Chairman. First, I would ask procedurally that the list of 26 priority documents that I handed, or that was handed to Mr. Rodriguez during my first round of questions be admitted into the record. Mr. Ivey just said a judge wouldn't bother with this. Just want to make a little comment about that. I was a judge, and I would tell you I would have bothered with this, because if it was brought to me, I didn't like it when parties played shell games with discovery in lawsuits, and I frankly wouldn't put up with it. And I would make parties produce relevant documents that they needed to in a lawsuit. Mr. Swalwell also called this hearing a waste of time. Ms. Bumpus, I want to ask you, do you think it's a waste of time for this committee to seek information on behalf of the U.S. taxpayers that they deem relevant through their duly elected representatives in Congress?
No, I don't.
All right, Ms. Bumpus, thank you for that. I appreciate that answer, because I don't think it's a waste of time either. I think it's exactly what we should be doing. Did you discuss with Chairman Jordan and Senator Cruz's, March 10th letter with Chair Khan?
No, I did not.
Did you discuss the letter with Chair Khan's chief of staff or any of her other direct reports?
I believe I did engage with her chief of staff.
Okay, only her chief of staff?
I'm sorry, I think I did speak to Chair Khan briefly when we received the letter as well.
And what was the nature of those discussions?
To inform them that we had received the letter.
And that was all the discussion was?
That was the essence of the discussion.
And then did you follow up with Chair Khan's chief of staff?
I think the process when we receive requests for non-public information under the Commission's rule is to refer the request to the Office of General Counsel. Those requests are then sent to relevant offices and bureaus around the Commission, depending on the nature of what's being asked for a response.
As it relates to the nature of what's being asked for in the March 10th letter, who would be responsible for collecting the documents in response to the March 10th letter?
I think we have staff throughout the Commission who may have those records, who are working on the response.
Can you identify any of those staff?
Not at this time, no.
Can you identify a supervisor or somebody over those staff that we could go to figure out exactly who's going to respond to the March 10th letter?
I believe it would be the Bureau of Consumer Protection.
Do you know if any of the documents have been collected to date in response to that March 10th letter?
I don't know.
Do you know who would know that?
I don't know. I'm happy to get back to you on that.
Do you know whether or not any text messages have been collected in response to the March 10th letter request?
I don't know.
Again, would you know who would know that?
I'm happy to get back to you on that.
All right, can you get back to me this week?
I'm happy to inquire.
All right. Has anybody told you or not to produce any specific documents to the committee that are responsive to the March 10th letter?
Not at all. The committee has not refused to produce any documents.
Are you aware of anyone being told not to produce specific documents that are responsive to the March 10th letter?
Not at all.
Does the FTC ever brief Congress on non-public investigations?
Yes, we do.
Why would this investigation be any different?
I believe that providing non-public briefings, which we do at the request of chairman and subcommittee chairman of relevant committees, is often the fastest way to inform those committees, and we have engaged in that practice for many years and continue to do that.
I assume then that the FTC also briefs the White House on non-public investigations. Is that true as well?
Not that I'm aware of, no.
One of the requests in the March 10 letter is for communications with the White House related to Mr. Musk. Do you know why none of these documents have been produced to date?
I'm not.
Do you know who would be aware of why those haven't been produced to date?
I don't know whether they exist, and I don't.
So can you tell me anybody at all, specifically by name, that's involved in responding to the March 10th letter?
My name is Jean Bumpus. I'm the head of the Office of Congressional Relations. I coordinate communications between the agency and the committee.
I appreciate that, but you really haven't given me any information today, and so I'm curious if you can give me the name of anybody with actual answers to my questions that relate to the March 10th letter and the response to that letter.
I'm happy to get back to you on that, Congressman.
All right, thank you. I yield back.
Thank you. The gentlelady from Florida is recognized. 5 minutes.
Thank you, Mr. Chairman. And Director Dunham, I'd like to spend a few moments discussing the FISA process. Now, would it be correct to say that the purpose overall of FISA is to collect information about espionage or terrorism from foreign powers or the agents of foreign powers?
That's certainly one of the reasons. I'll caveat, I'm not a subject matter expert on FISA.
It is the purpose being foreign intelligence information collection, correct? Now, it wouldn't be used, by contrast, for the purpose of collecting information for purely domestic criminal activity. Is that right?
I'm not a subject matter expert to answer any of those types of questions. What I can tell you is I know we've offered a pretty extensive substantive response to the committee's inquiries that we sent last week or the week before. 10 plus pages responding to your questions, plus 400 plus pages of document productions. And I believe we're in the process of setting up a briefing for committee staff and members. I know this is a topic that's really a legislative priority for the FBI. So I'm more than happy to get the right person in front of you to answer the questions related to FISA so that we can alleviate a lot of the committee's concerns and also educate on a lot of the reforms that we've put into place over the last 2 years that go to some of the heart of those concerns as well.
So as you sit here with us today, then, it would be your position that you are not qualified to share with us the scope of the FISA process and whether it might relate to, say, domestic criminal activity versus the collection of information about foreign adversaries and foreign terrorist threats.
I'm certainly not qualified on a lot of things in FISA. Getting to the bottom of FISA, the definitions, the ins and outs of the process, why we use it, the value of it, I would feel more comfortable having a subject matter expert come before you and really dig into it.
You are aware, are you not, that in the past, the Office of the Inspector General has concluded that the FBI has engaged in overreach as it relates to information collection within the FISA courts?
I'm aware of some of those reports, correct.
And this committee made a request of the FBI that states in part, the Office of the Director of National Intelligence's annual statistical transparency report revealed that from December 2020 through November 2021, the FBI conducted over 3.3 million U.S. person queries against its 702 holdings. This was a substantial increase from the number of U.S. person queries the FBI conducted from December 2019 to November 2020, which the report stated was approximately 1.3 million. Now, can you share for us today why that number increased?
I can't share for you the specifics. What I can tell you is I believe the response that you received on March 14th goes to the heart of a lot of those questions the committee had. And we are in the process of offering a briefer to go over a lot of the questions the committee has.
Can you tell us if you are have identified for us that you don't perceive that you are the internal subject matter expert on FISA at the Bureau. Who would be the person that we should bring in if we wanted to have a thorough discussion about the scope of FISA and the responses to our substantive requests?
We have a FISA team that's responsible for responding to congressional engagements, congressional information requests. I'm happy to have one of them come before the committee for a briefing. I think we're in the process of setting that up, actually.
All right. Thank you, Director Dunham. Mr. Chairman, I yield back.
All right, I thank the gentlelady. That concludes today's hearing. We thank our witnesses for appearing before the committee today. As we said, the more we hear from you between now and the next time, the less likely it is that we'll see you next time. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. Without objection, the hearing is adjourned.